Hello, I'm Matthew Gavidia. Today on the MGH Life Sciences News Network, the Center for Biosimilars is pleased to welcome Nicholas K. Mitrokostas, an intellectual property law attorney with Goodwin Proctor, Boston, and editor-in-chief of BigMoleculeWatch.com. Can you just introduce yourself and tell us a little bit about your work?
Sure, and good morning to everyone. I'm a partner in Goodwin's Boston office. I focus on life sciences litigation, and in particular, I advise companies who are working in the pharmaceutical space with respect to intellectual property matters and, in some cases, regulatory matters. And I'm also have been involved in advising companies and representing them with respect to their biosimilar products.
Yesterday, Pfizer announced its pegfilgrastim biosimilar, Solizumab that was approved by the FDA. This marks the first biosimilar approval this year. As most of us thought biosimilar momentum would be faster this year, is this a sign of COVID-19's impact, or is something else happening?
Well, I think we need to put this into context that there have been 28 approvals of biosimilars since the enactment of the BPCIA. And while obviously, Pfizer's pegfilgrastim was the first one announced in 2020, and then yesterday we had another announcement of an insulin biosimilar for Mylan Biocon, so that's number two. I think there's sort of two reasons that we may not have seen more approvals this year, although the year is, far from over. One has to do with the fact that, we saw an initial wave of biosimilar filings as a result of exclusivities that had already expired or were very near expiry following the enactment of the BPCIA. And so for those, we have seen a number of filers who have received approval, and many of which have launched. And I think then now we're sort of heading into the second wave, so to speak, of molecules that are nearing the end of their exclusivity period. So I suspect that we're going to see more filings in the coming year and years. And there are, I think that's, the first issue here is that, biosimilars applicants sort of time their filings with respect to when molecules are nearing the end of their exclusivity period from FDA. The second one obviously probably has to do in some degree with COVID, and everything is obviously functioning much slower than it otherwise would be with COVID. But I don't think that these will be the only two approvals that we'll see this year.
The FDA generally doesn't disclose the drug applications it has received, but do you have a sense of how robust the pipeline is?
That's right. So while we don't have any guidance from FDA with respect to who has filed and what is pending, there is information that can be gathered from publicly available sources. For example, either earning calls or SEC filings from a number of the publicly listed pharmaceutical companies who are working in this space. And so we know there are many more files that are sort of under development or have been filed. So for example, Mylan announced that its bevacizumab biosimilar was accepted, and there's a user fee deadline of December 2020 for that. In addition, Coherus and BioEQ had previously filed ranibizumab biosimilar. It was withdrawn, but they recently announced again that they're going to refile it in the second half of 2020. And Coherus has announced that it will file its AMAB molecule as well. So I think we do have a sense from public sources that companies are still very active in the development of biosimilars and are filing them, and that there are a number that are still under review with FDA.
What does the rest of the year look like for biosimilar approvals, do you think?
I think we're going to see some more approvals. Maybe I'm being optimistic here, but I do think that FDA will be sort of poised to approve some more biosimilars, and I also think we're going to see a number of more filings given the activity that's out there and that people have been describing in their public earnings calls and SEC filings with respect to some of the molecules that are nearing their expiry date. So, for example, Lucentis, which is the ranibizumab molecule, is having an end of expiry of exclusivity pretty soon. Similarly, Eylea, aflibercept, is nearing the end of its exclusivity period, and a number of companies have publicly stated that they're working on molecules or biosimilar filings for those molecules.
Meanwhile, we're seeing a number of biosimilars that have been approved but are not yet launched. Wasn't the patent dance process supposed to shorten the time between approval and launch?
Well, the patent dance process was intended not necessarily to shorten the time between approval and launch per se, as much as get some clarity in the resolution of patent disputes so that when a product is approved, the biosimilar manufacturer knows whether or not there's freedom to operate or patent clearance for them to enter the US market and what the risks are associated with doing so if there isn't. And I think the patent dance and the mechanisms that were enacted as part of the BPCIA so far have been successfully achieving that goal in the sense that we have seen a number of these patent disputes resolved either by court decision or settlement. During this time period between the filing of the ABLA application and the approval date, for some of these, obviously, the decision is adverse to the ABLA filer, or it's a settlement whereby the ABLA filer agrees to stay off the market for a certain period of time. So, for example, in the case of Humira and adalimumab, we know that there are a number of filers who have gotten approval, but through settlement have agreed not to launch their products until a date in the future. And so, the patent dance actually facilitated those settlements in a way that was contemplated by the BPCIA. So I think it is essentially achieving the purpose that it was meant to achieve, which is giving clarity to biosimilars manufacturers as to what the risks are associated with bringing their molecules to the market once they get FDA approval.
The new approval pathway under the BPCIA gives instant biologic drug license status to products previously approved under the FD&C Act. Is this the seamless change that the FDA has described?
So I believe you're referring to the deemed to be a license provision under the BPCIA, which essentially provided a 10-year window within which products that were previously approved as NDAs, for example, insulin glargine, would transition 10 years after the enactment of the BPCIA, so this March, to BLAs without sort of having to refile the application and get new approval, and also then provide a pathway for which a biosimilar can come to the market through an ABLA. And it has, since we passed that, March 2020 date, it has essentially worked, I believe, the way it was contemplated to work. FDA did sort of iron out some of those issues last year through some guidances, and in addition, we saw in Congress's Budget Appropriations Act at the end of last year some further actions to try to facilitate the approval of biosimilars to some of these molecules. So, for example, as we talked about a short while ago, Mylan got approval for its insulin glargine product that was originally filed as an ANDA because insulin glargine had been approved as an NDA. In March 2020, that insulin glargine molecule sold as Lantus was deemed to be a BLA under the BPCIA, and Congress made clear that ANDAs that were pending, at that time of the transition date would continue to get, reviewed and approved without the need to be refiled as ABLAs. That was sort of an open issue and question that FDA and stakeholders and others have been weighing into for the last several years with this transition date in mind, is what would happen to these pending ANDAs. But as we saw, there was some clarity to it, and now Mylan Biocon did get approval for their product. So from that perspective, there was a sort of seamless transition for the molecules that fell under this deemed to be a license. FDA is still, or has been earlier this year, still addressing sort of the definition of protein, which impacts obviously which of these molecules sort of are, would fall under the provision, and also like sort of the scope of the deemed to be a license provision. But I think so far things have been working as they intended.
What do biosimilar manufacturers need to know about this to make effective decisions about product applications, particularly those for insulins?
So there's been a lot of FDA guidance that has come out around the deemed to be a license provision, as well as the manufacture and development of a biosimilar insulin product. So for example, we saw in November of 2019, FDA issuing guidance about risks associated with immunogenicity in the development of insulin products. And FDA has, obviously did that in anticipation of the fact that the deemed to be a license transition date was going to be in March 2020. I think what's clear from all of this is that, the key takeaway is that FDA is obviously interested in seeing robust data from an applicant with respect to the highly similar prong and no clinically meaningful differences prong of the standard for demonstrating biosimilarity for insulin products. And so developers of these products, I think are taking that guidance into account, and would be advised to probably speak with FDA about the plan for demonstrating, that their biosimilar is highly similar to and shows no clinically meaningful differences from an approved insulin product.